students. I hope your preparations are going amazing. And today we are going to discuss the RTE of the September exam, September 25. Questions are quite interesting, so please pay attention throughout. And while I'm reading, please analyze and try to answer the questions on your own also before I give you the answer. And let's see how many of you get all the questions right. And I'm pretty sure you would. One very important thing about the OPC, I have put up a video where I am talking about what amendment, not amendment, rather rectification has been made by the ICI. If you have not watched the video, I have put a link of that video even in the description box below. So please do go and watch it because it's a very, very important rectification and you cannot miss it. So let's get back into this. Generally, I don't discuss the direct questions because it's direct, there is nothing to discuss, but still just we will just do an overall thing on that. So the first chapter, Indian Regulatory Framework, explain the hierarchical structure of the Indian judicial system. Describe the powers and functions of the Supreme Court, High Court, District Court, and Metropolitan Court. So basically, the hierarchy, if I talk about, the hierarchy is at the top is the Supreme Court, then High Court, then District Court, then Metropolitan Court. So High Court, Supreme Court is at the top, and High Court. Every state must have a High Court. There are 25 High Courts, and the decisions of Supreme Court is binding on all the other courts. The Chief Justice is there, is the topmost authority, and there are earlier it was 7, but now there are 34 judges. Then High Court. Every state has one High Court. For fundamental rights, we can directly go to the Supreme Court also. We can directly go under Article 32, and we can directly go to the High Court also. District court is below the High Court is the district court, and pecuniary jurisdiction is up to 2 crores. And below the district court is metropolitan magistrate. Every metropolitan city or any city with a population of 10 lakh or more must have a metropolitan court. Coming to the questions of Indian Contract Act, we have a different kind of love. It's like a love-hate relation when it comes to Indian Contract Act, right? It's like Tom and Jerry relationship, the love and hate relationship here. So let's look into the question. And as I told you, I want you also to figure out the answers even before I give the answer. Albert obtained two loans of 3 lakhs and 4 lakhs, respectively, from a reputed bank. Out of these, loan of 3 lakh was guaranteed by Robert. Albert sent 2 lakh to bank but did not initiate as to how it is to be appropriated towards the loans. The bank appropriated the whole of 2 lakh to the loan of 4 lakh. So the debtor, Albert, has made a payment of 2 lakh, but it did not inform to the bank as to how to set off that loan. In case of appropriation of payment, the first right to decide which debt to set off is with the debtor. And when he makes a payment, he can specify which debt must be set off. And if the creditor accepts the payment, he must set off that debt only. But if the debtor does not specify anything, the creditor may at his discretion set off any debt, including a time bar debt. Here, the bank appropriated the whole of 2 lakh against the 4 lakh. Can the bank do so? Yes. Creditor's discretion which debt to set off. Robert objected on the decision of the bank. He argued with the bank that repayment amount should be first adjusted to the guaranteed loan. Is he correct? No, because when the debtor does not specify anything, the creditor can set off any debt. State with reasons whether the bank was correct in its decisions under the Indian Contract Act. Yes. And here you will write about the appropriation of payment, the provision where the creditor has a right to decide which debt to set off if the debtor does not specify anything. Yes, Sarthak. So moving on to the next question. Yes, Sarthak Jain has decided to get interior work for his new office. For this purpose, he entered into a contract with Messrs. Sherry Fine Interiors. It was agreed that Messrs. Sherry Fine Interiors will complete the interior work up to 31/1/25. The work should be completed on 31/1/25. On 31/1/25, CA Sarthak Jain observed that only 20 to 30% work is completed. Right? The contract has specified the time for within which the work should be completed. He decided to cancel the contract with them. Messrs. Sherry Fine Interiors filed the suit against CA Sarthak Jain for recovery of the cost which he incurred on the interior work. First of all, here the time was given, right? And when the time is given, whether it is of essence or not depends on the terms of the contract. From here, it is very much evident that only 20 to 30% of the work was done. That means almost all of the work is not done. So that means in this case, the contract will become what? voidable at the option of Sarthak Jain. Voidable means I can cancel, I can accept. So he decided to cancel. Can he do that? Yes. Messrs. Sherry Fine Interiors filed a suit against C.A. Sarthak Jain for the recovery of the cost which he has incurred on the interior work. C.A. Sarthak Jain argued that they did not complete the work within the time as per the contract, and further, the work done till this day was of no use to him as he has to appoint a new interior designer. Now, if part of the work, when the contract is not separable and a part of the work is done, and that part is of no use to the other person, he is not liable to pay. Here, he is saying that the work which has been done is of no use to him as he has to appoint new interior designer. That means this he cannot enjoy the benefits of the work done, right? He cannot enjoy benefits of the work done. And when you cannot enjoy benefits of the work done, the contract becomes what? Void. Explain whether C.A. Sarthak Jain is liable to pay the cost of work done by Messrs. Sherry Fine Interiors under the provisions of the Indian Contract Act. Is he liable to pay? No. Why? Because the work was not completed and the work that was done is of no use to him. Rohan of 17 years has purchased a mobile of 25,000 for his online classes from Mobile Sales Center on credit. On due date, he did not. So it is for his online classes, education. And education is considered as what? Necessaries, correct? From Mobile Sales Center on credit. On due date, he did not make the payment of mobile. Mobile Sales Center sued Rohan and his parents for the price of the mobile. Parents, are they liable? The parents are only liable for the act for which the minor acts as an agent and they have given an authority. Here, nothing is given about the authority. So, are the parents liable? No, parents are not liable. Rohan has 15,000 as his cash balance, but his father has enough money to pay the price of the mobile. Doesn't matter, even if his father has the money, he's not liable to pay. Rohan has 15,000. That means, can I say, when we supply necessaries to a minor, the minor is not personally liable, the liability is against the minor's property. Here, he has a property of 15,000, so I can recover 15,000. Given situation, answer who will be liable to pay the price of the mobile. So, parents are not liable. Rohan is liable, but no, Rohan is also not liable personally. So, he is liable only for the assets. He has assets of 15,000. What is his liability? 15,000. What about the 10,000 remaining? Company, the shop will not get it. Next question. Hill ordered 100 kgs of wheat to Messrs. Sahil Kirana store and it promised to supply for wheat by the evening. In the evening, the hawker of Messrs. Sahil Kirana store comes with 100 kgs of wheat, but mistakenly he delivered it at the house of the neighbor of Akhil. Goods delivered by mistake. Right? Goods delivered by mistake. Referring to the provisions, advise who will be liable to pay the price of the wheat. Since I never got the goods, why will I pay? My neighbor got it and he kept it. So, under quasi contract, there is no contract between the neighbor and the Kirana store. But under quasi contract, the neighbor is liable to pay. Correct? The neighbor is liable to pay. Rahul hired a car for 15 days from Messrs. Kushwa Travels. After 5 days, Messrs. Kushwa Travels, he is hired. Gratuitous or non gratuitous? Non gratuitous. After 5 days, it was hired for 15 days. After 5 days, Messrs. Kushwa Travels demanded back his car from Rahul. He was also agreed to compensate for any loss suffered by Rahul due to such premature return of goods. First of all, if it is a gratuitous bailment, it can be terminated at any point of time. But if it is a non-gratuitous bailment, it cannot be terminated before the time. But Rahul refused to return the car before the period of bailment, that is 15 days. Messrs. Kushwa Travel sued Rahul for recovery of the car. Can they recover the car? No. No. If it was a gratuitous bailment, they could have recovered the car at any given point of time. But since it's a non-gratuitous bailment, it cannot be terminated at any time. So they cannot recover the car. Ajay appoints Vijay to sell his electronic goods lying in his godown. He also agrees to give 10% commission on the sale price to Vijay. Afterwards, Ajay revokes Vijay's authority by sending the letter to Vijay. The letter was sent on 3rd March, which was received by Vijay on the 7th March. Okay. Letter was dispatched on the 3rd but received on the 7th. As far as termination of agent's authority is concerned, termination of authority takes place only when the agent receives the notice of termination. So even though the notice was sent on 3rd, termination will take place only when the agent receives the notice, which is the 7th. In between this period, if the agent does any work, the principal is liable. Which was received by Vijay on 5th March, Vijay sold the goods worth 1,20,000. Between this period, that is on the 5th, he sold goods worth 1,20,000. Is Ajay bound by this sale? Yes, because it happened before the termination. But ma'am, termination notice was given on the 3rd. What did I tell you? For the agent, termination takes place only when he receives the notice of termination. He claimed for commission from Ajay, but Ajay refused as he already revoked the agency. Whether Ajay was liable to pay commission? Yes. He is liable to pay a commission of 12,000 to Vijay because the sale was made before the termination of agency. Explain the concept of quantum merit with reference to the Indian Contract Act. So basically, it's as much as is done. When the contract is separable and you have performed a part, payment shall be made for the part performed. If the contract is not separable, you're not liable to pay. But if the other person accepts, you have to pay. If the contract becomes void subsequently, then whatever work is done, you have to pay for the work already done. If the contract is done without an intention to do the work gratuitously, then you are liable to pay for the work done. Again, if a contract has been performed, not performed in the way the other party wanted, but still done, you have to pay a reasonable sum of money. But remember, the claim for quantum merit arises only when the original contract has been discharged. And second, the claim is made by a person who is not a party to the default. Define co-sureties. What is co-sureties? When two or more persons have made a joint promise, they are known as co-sureties. State the rights available to the surety against the co-sureties relating to contribution. If we are bound by equal amount, they are liable to contribute equally. If they are bound by different amounts, they are liable to contribute to the extent of amount of contribution that they are liable for. Okay, so moving on to the Sale of Goods Act. Mr. G sold some goods to Mr. H for a certain price by issue of an invoice, but payment in respect of the same was not received on that day. The goods were packed and lying in the godown of G. The goods were inspected by H's agent, were found to be in order. Later on, the dues of the goods were settled in cash. Just after receiving the cash, G asked H that the goods should be taken away from his godown to enable him to store some other goods purchased by him. Just 1 second, guys. Mr. G asked Mr. H that goods should be taken away from his godown to enable him to store some other goods purchased by him. After one day, since Mr. H did not take the delivery of the goods, G kept the goods out of the godown in open space. Due to rain, some goods were damaged. See, as a bailee, I should take care of the goods. So, whoever has the possession of the goods, he should take care of the goods. But here, G had already informed H that please take the delivery of your goods. The goods were already ascertained, the goods were checked, inspected, everything was in order. But still, H did not take it. Whose fault was it? H's fault. Who will bear the loss? Obviously, H will bear the loss. So, who will be held responsible for the above damage? H. Will your answer be different if the dues were not settled in cash and still pending? Doesn't matter. Even if the dues are not settled in cash, it is H who is the owner of the goods, right? And second, also, it was because of H's fault that the goods were not taken. G was ready to give the delivery, H was not in a position to take. So, it is still H who will bear the loss. Mrs. Seema went to the local rice and wheat wholesale shop and asked for 100 kgs of basmati rice. The shopkeeper quoted the price of rice as 125 per kg, to which she agreed. Mrs. Meena insisted that she would like to see the sample of what would be provided to her by the shopkeeper before she agreed upon the purchase. The shopkeeper showed her a bowl of rice as sample, right? So The sample exactly corresponded to the entire lot. The buyer examined the sample casually without noticing the fact that even though sample was of basmati rice, it contained a mix of long and short grains. That means what? Here, he had examined the sample but very casually. So, if you see here, what they have given, he examined it casually, and the sample was basmati, long and short grains. The cook, on opening the bag, complained that the dish, if prepared with the rice, would not taste the same as the quality of rice was not as per the requirement. Now, Mrs. Seema wants to file a suit of fraud against the seller, alleging him of selling a mix of good and cheap quality rice. Will she be successful? Now, here there can be a doubt whether I should write as per caveat emptor or should I write as per sample, sale by sample. So, see here, in this question, very clearly, they have used the word sample, sample, sample again. So, obviously, this question is about sale by sample. So, would she be successful? No. The reason being, if you look here, what is said, the sample corresponded to the entire lot. So, the goods are as per the sample. She examined the sample, she has seen it. It was her fault that she did it casually without noticing that there was a mix of long and short grain. So, whose fault is it? Her fault. So, can she return the goods back? No. What would be your answer in case she specified her exact requirement as to the length of the rice? Now, when she specifies her exact requirement as to the length of the rice, it would be specific purpose of the buyer. And if it is specific purpose of the buyer, then obviously you have already specified the reason of the purchase, and it is the seller's duty to supply you the goods which suit your purpose. And if he does not, can you return the goods back? Yes. So in this case, she can return the goods back. Next, Raghav arranges an auction to sell an antique wall clock. Deepa, being one of the bidder, gives the highest bids. For announcing the completion, the auctioneer falls the hammer on the table, but suddenly the hammer breaks and damages the clock. Deepa wants to avoid the contract. Can she do so? Now, at the time of knocking the hammer, the clock breaks. Sale is complete after the fall of the hammer, not at the time of the fall of the hammer. The moment you try to fall the hammer, it breaks and the clock is broken. So, is the sale even complete? No. So, can she avoid the contract? Yes, because the sale is not complete. X contracted to sell his car to Y. They did not discuss the price of the car at all. X later refused to sell his car to Y on the ground that the agreement was void, being uncertain about the price. Can Y demand the car under the Sale of Goods Act? In Sale of Goods Act, price is essential. However, if the price is not fixed, the contract does not become void. If the price is not fixed, even then the seller will get a reasonable price. The buyer is liable to pay a reasonable price. State the various essential elements involved in unascertain goods and their appropriation. Unascertain goods ownership is transferred after they are ascertained and appropriated. Ascertaining is identifying the goods and keeping them aside, which is done only by the seller. Appropriation is selection of the goods for the mutual consent with the mutual consent of both the parties for the performance of the contract. When we talk about appropriation, the essentials of appropriation are the goods must be in a deliverable state. The goods must be first goods must be identified. They must be in a deliverable state. They must be appropriation must be done with the consent of both the parties. Appropriation can be expressed or implied, and it can be done before or after the delivery of the goods. What are the consequences of destruction of specified goods before making of the contract and after the agreement to sell under the Sale of Goods Act? Okay. In case of destruction of subject matter, there are two things: before agreement, after agreement, before sale. Before agreement, if anything happens to the specific goods, the contract is void ab initio, bilateral mistake. After agreement, but before sale, if anything happens to the goods, it's destruction of subject matter, supervening impossibility, and the contract is void. What is the concept of reservation of rights to disposal? So this is one topic which is, I don't know why students find it very difficult. So I'll explain it a little bit here so that you get to know also. Reservation of rights to disposal means, see, I have sent the goods to you or I have transferred the ownership of the goods to you, but you have not paid me the price. And there is always a risk that I may not get the price. So to, safeguard my price, I put a condition that if these conditions are fulfilled, only then you will get the possession or you will get the delivery of the goods. So reservation of rights to disposal is basically done with only one motive, and it is to secure the money, secure the payment. So when I talk about reservation of rights to disposal, the seller can tell the carrier that even if the goods reach the buyer, don't hand over the goods to the buyer unless I tell you. So he has kept in his control the final delivery of the goods to the buyer. He has reserved the rights of disposal. Similarly, if I am giving you a document of title, you become the owner of the goods. But if I give you document of title along with a bill of lading, it's a conditional transfer. If you want to become the owner of the goods, you have to accept the bill of exchange. You keep the bill of exchange. You keep the bill of lading and you return the bill of exchange without accepting. Generally, you have the bill of lading, you are the owner. But here, even though you keep the bill of lading, because you did not accept my bill of exchange, you will not become the owner. So by doing this, I have created a security for my money that I'm sure my money will come to me. This is reservation of rights. So we are done with Sale of Goods Act. Moving on to Partnership Act. A and B are partners in Messrs. A, B, and Company. Firm is doing business of trading of plastic bottles. A and B are partners in Messrs. A, B, and Company. Firm is doing business of trading of plastic bottles. A is authorized to sell the stock of plastic bottles. It was decided between them that A should sell the plastic bottles at the minimum price which they have decided. And if A sells at a price less than the minimum price, he should first take the permission of B. So this is what this is. They have limited his authority that you cannot do more than that. Due to sudden change in government policy, the price of plastic bottles was continuously declining. To save the loss of firm, A sold the stock at lower price. Meanwhile, A tried to contact B but couldn't do so as B was on a foreign trip. Afterwards, when B came, he filed the suit to recover. Okay. Acts in emergency. Generally, a partner cannot do anything that is outside his authority, and if he does, the firm is not liable. But here, the act was done to protect the interest of the firm, and he was not in a position to communicate with the other partner. In this case, is the firm bound? The firm is bound. So, whether B can do so? Absolutely no. In an emergency, when a partner acts outside his authority to protect the interest of the firm, the act done by the partner is binding on the other partners, even though if it was not in his authority. So, the firm is bound by the act is valid, we cannot sue. Can a partner be expelled? Yes. If so, what factors should be kept in mind? There should be an agreement authorizing the expulsion. The consent of majority should be taken and the expulsion must be in good faith. If it is not in good faith, it's null and void. What is good faith? It's in the partnership interest. Partner to be expelled is served with a notice and he's given an opportunity of being heard. Mr. Ram and Mr. Rahim are working as teachers in Ishwar Chand Vidyasagar High Secondary School, and also are very good friends. They jointly purchased a flat which was given on rent to Mr. Jones. It was decided between the landlord and the tenant that, okay, they have purchased and gave it on rent. Rent is not partnership. Renting of property is not partnership, right? It was decided between landlord and tenant that the rent would be 10,000 per month inclusive of electricity bill. It means electricity bill will be paid by the landlords. Will be paid by the landlords. The landlords, by mistake, did not pay the electricity bill for the month of March. Due to this, the electricity department cut the connection. Mr. Jones had to pay the electricity bill of 2,800 and 200 as a penalty to resume the electricity connection. Mr. Jones claimed 3,000 from Ram, but Ram replied that he is liable only for 1,500. Mr. Jones said that Ram and Rahim are partners. Are they partners? No. Therefore, he can claim the full amount from any of the partners. Now, they were partners, he could have recovered the money from any one of them. But We have already discussed that renting of property is not considered as partnership. Since it is not partnership, they are not partners. And if they are not partners, they are only liable for their share and not for the other's share. So, the legal position and the correctness of the liability of Ram to pay the whole amount. Well, first of all, it's not partnership. Second, so you're going to write about how do you know whether there is a partnership or not. And second, because they are only joint owners, they are only liable for their share. So Ram is only liable to pay 1500 and not 3000. The rest 1500 he can only recover from Rahim. Explain in detail the circumstances which lead to the liability of the firm for misapplication by partners. So, when a partner acting in the ordinary course of the business receives any money from a third party on behalf of the firm and misuses it, or when a third party pays money to the firm and a partner misuses it, in both the cases, who is liable? The whole firm is liable. P, Q, and R formed a partnership agreement to operate motor buses along specific routes for a duration of 12 years. After operating the business for 4 years, it was observed that the business incurred losses each year. It was formed for 12 years, but after 4 years, there was loss. Despite this, P is determined to continue the business for the remaining period. Examine with reference to the partner, can P insist to continue the business? Yes, he can, because a firm cannot be dissolved without the consent of all. And unless he gives the consent, the firm cannot be dissolved. If so, what options are available to Q and R who are not wanting to continue operating the business? If they don't want to continue to operate the business, consent of all is not given. They can move to the court to dissolve the firm, right? Next, A and B operate a textile merchant business in partnership. A finances the business and is a sleeping partner. In the regular course of business, B acquires certain fabric goods belonging to C. However, B is aware that these goods are stolen property. Despite this knowledge, B proceeds to purchase and sell some of these stolen goods. Moreover, B records the proceeds from these sales in the firm's book. Later, A comes to know Later, A comes to know of the fact of B's conduct of the transaction with C. So he decided to avoid his liability towards C. Can he do that? No. The whole point is that A has done the act in the ordinary course of B has done the act in the ordinary course of the business, and he was operating the business with the consent of the other. In such a case, if any partner misapplies anything or does any wrongful act or does any misconduct, the whole firm is liable. Also, the act was done in the ordinary course of the business. Since the act was done in the ordinary course of the business, obviously the firm is liable. So A cannot avoid. Discuss the liability of A and B towards C. They are liable, they both are liable to C together. Comment upon the decision of A in the said transaction. He cannot say he is not liable. He cannot abstain from his liability. He is liable to contribute to C just like partner B. Explain now LLP. Explain the legal provisions regarding the eligibility of persons to become partners in an LLP under the LLP Act. What are the consequences of if the business is carried for with less than two numbers for more than 6 months? So, uh, in case of an LLP, any individual or a body corporate can become a partner of the LLP. An individual is disqualified from becoming a partner if he is uh, found to be of an unsound mind by a court of competent jurisdiction and the finding is in force, or he has applied to the court to be declared as an insolvent, or he's an undischarged insolvent. If the number of members is reduced below 2 and the LLP continues its business for more than 6 months, then in that case, if the sole partner who had knowledge of the reduction shall be personally liable for the obligations of the LLP incurred during this. Tycoon Private Limited, now Companies Act questions. Tycoon Private Limited is the holding company of Glassware Private Limited. As per the last or profit and loss account for the year ending 31st March of Glassware Private Limited, its turnover was 1.8 crores and paid up capital was 80 lakhs. The board of directors wants to avail the status of a small company. See, for small company, 40 crore turnover, 4 crore paid up capital. So both is within the limit. Both is within the limit. The company secretary of the company advised the directors that it cannot be categorized as a small company. You are required to examine whether the contention of company secretary is correct. Both the conditions are fulfilled. But if you are a holding or a subsidiary company, you don't get the status of a small company. Here it is given that it is the subsidiary of Tycoon Private Limited. So it cannot get the status of a small company. So is the contention of the company secretary correct? Yes. In the Flower Fans Private Limited, there are only 5 members. All of them went on a pleasure trip in a boat. The boat overturns and all of them were drowned. Is Flower Fans Limited no longer in existence? Perpetual succession. Death of a member does not result in the death of a company. Even if all the members of the company are dead, the company shall continue. Further, it is correct to say that a company being an artificial person cannot own property and cannot sue and be sued. No. Company being an artificial person can own property in its own name. It can hold property whether tangible, whether intangible, whether movable, whether immovable. Also, the company has a right to sue the third party in its own name, and also company can be sued in its own. An employee, Mr. Karan, signed a contract with his employer company that he will not solicit the customers after leaving the employment from the company. But after Mr. Karan left ABC Limited, he started up his own company, PQR Limited, and started soliciting the customers of ABC for his own business purpose. ABC filed a case against Karan for breach of employment. So when he could not do it, he started this company, and through this company, he started dealing with the clients of ABC for breach of employment and for soliciting their customers for the business. Karan contended that there is a corporate wheel. So there are certain cases where the corporate wheel is lifted. This case is the same case as Guilford Motor Company versus Horn, right? So it seeks your advice as to the meaning of corporate wheel. Here the question is different. They are not asking you for this. They are asking you the meaning of corporate wheel. So you have to explain the concept of corporate wheel and when the wheel can be lifted. So you have to give all the cases where the wheel can be lifted. Pacific Motors Limited is a government company. Rama Auto Private Limited is a private company having a share capital of 10 crores in the form of 10 lakh shares of 100 each. So how many shares are there? How many shares are there? Total number of shares here is 10 lakh. And out of this, Pacific Motors is holding 5 lakh 5,000 shares. 5 lakh 5,000 shares are held by Pacific Motors. That means, can I say it is more than half? That means, can I say Rama Auto Private Limited is a subsidiary of Pacific Motor Limited? Yes. It is a subsidiary of Pacific Motor Limited, which is a government company. So it's a subsidiary of a government company. Advise as the whether Rama Auto Private Limited is a government company. Subsidiary of a government company is a government company. So is Rama Auto Private Limited a government company? Yes. So moving on to negotiable instrument. Aman drew the bill of exchange on Baban, who accepted it payable to Magan or order. Magan endorsed the bill to Gagan. Gagan endorsed the bill to Akash to be delivered to him on the next day. However, on the death of Gagan on the same day, his only son Ankit delivered the bill to Akash on the next day. Is it a valid delivery? Endorsement is valid only when it is completed by delivery. Delivery has to be done only by the endorser. The legal heirs of the endorser cannot endorse the instrument on the death of the endorser, and such an endorsement, such a delivery is not valid. So, on presenting the bill on the due date, Baban refused to pay. Examining the importance of decide whether Akash can recover the payment of the bill against Baban or the previous parties. No. Endorsement is valid only when it is completed by delivery. Here, since the instrument was not completed by delivery, the endorsement is not valid. The legal heirs cannot complete the delivery on behalf of the endorser on death. So he cannot recover. Reliable Reliable Limited, an Indian company, is a global leader in petrochemical products for payment of the sale price of machinery imported from LX Manufacturing Limited, a US based company. The Indian company drew a bill of exchange on Manish, a resident of Mumbai, who accepted the bill of exchange payable in Los Angeles, US. Decide whether the bill is an inland instrument. You are an inland instrument if you are drawn in India and you are either drawn on a person resident in India, or you are drawn payable in India. Here, since the instrument was drawn by an Indian company, it is drawn in India. Yes. It is drawn on Manish, a person resident of Mumbai. So it's drawn on a person resident in India. Out of these two, any one is enough to make it an inland instrument. Even though it was payable in US, it was drawn in India on a person resident in India. So yes, it is an inland instrument. A promissory note payable at a certain period after sight must be presented to the maker, under which scenario presentment for payment is not necessary and the instrument is dishonored at the due date for presentment. When the presentment is supposed to be made at a specified place and the person is not uh, I mean where the drawer, or rather it's promissory note, so where the maker avoids the presentment, or it was supposed to be presented at the business place and the during the office hours the business place is logged, or it was supposed to be presented at some other specified place and the person is not present at that specified place, or after reasonable search we are not able to find that person. In this case, presentment is not necessary. So with this, we are done with the RTP discussion. I hope your studies are going well. Keep studying, happy learning, and stay motivated. Thank you so much.